Welcome to Cocktails, Conversation, and Community program. Tonight, we are very excited to have Megan Wallace joining us. Megan is the principal and founder of Wallace Law, and she's been active part of the legal and business community for many years. Megan is licensed in Maryland, Virginia, and DC, and practices regularly in all of those jurisdictions. So those of you joining us from villages in Montgomery County or Virginia, you are more than welcome to call Megan after the program and see what help she can offer you. Megan concentrates much of her practice in the areas of estate planning, trust administration, and probate, in which her background is in business law and tax law is highly relevant. In addition, Megan has a number of years of experience teaching at American University and has been dealing with the pandemic through teaching online and getting through as well as the rest of us. So she's learned along with us Zoom and the other tricks of the trade in terms of having online programming. Megan drafts estate planning documents customized to each client's individual needs, and she's well aware of the intricacies and different situations that people experience as they go to make their plans. Megan also often volunteers her groups and her expertise, speaking to groups such as ours. And we are very grateful and thankful to have Megan here with us today. Megan has generously offered that if you have questions during the presentation, you don't need to wait till the end, that she is happy to answer questions during the presentation. If you'd like to put it in the chat, I will be happy to recognize you and ask your question for you. And if you'd like, to ask your own questions, of course, we welcome you to do that. Feel free to, just kind of raise a hand or in some way indicate that I will know that you wish to unmute. You may unmute yourself to ask your question, and then I will ask you to remute yourself so that there's not a lot of background noise during Megan's presentation. Again, we thank all of you for joining us, and we particularly thank Megan for being with us this evening. So Megan, without taking up any more of your time, I welcome you to Georgetown Village Cocktails, Community, and Conversation, and the room is yours.
Okay, well, great. Lynn, thank you so much. I really appreciate that. I'm looking forward to the community and conversation part. Hopefully you have your cocktail. I'm working on a green tea myself. You may have something more interesting. So what I had said to Lynn is I would love for this to really just be, a conversation. I certainly have, a presentation to make and an agenda, as far as like a guide, but I would welcome your questions. Perhaps you've been through the probate process or even the estate planning process, years ago, or perhaps more recently. And I really would be very happy to answer your questions. As Lynn mentioned, I do teach at AU Law. I teach wills, trusts, and estates, but I am a full-time practitioner. And my favorite part of my job with my clients, as well as my students, is the education component. So I would love to answer any questions you have as they come up. My plan for today is to really walk you through a comprehensive estate plan. A lot of people hear the word an estate plan and they think, oh, I don't have an estate to plan. I'm not I'm not Bill Gates or something of that nature. Well, everybody does actually have something to plan for, whether that is, an unused portion of a Social Security payment or maybe an IRA or something that you have. And also everyone actually has an estate plan in place that was actually put together for you in DC, under the laws of the DC code. So if you choose to use that as your estate plan with no customization, then you have something that will happen. And what that looks at is really kind of the familial lines, and it doesn't allow for anything interesting or out of the ordinary. So it doesn't allow for any type of charitable contributions or anything of that nature if that's of interest to you. But all of that is to say that you can actually change that plan that the city has in place for you by drafting and having your own will in place, possibly even a revocable trust. So I'm going to start by sharing my screen here. Okay. I really love the name of your Cocktails, Conversations, and Community. I think that's just a really nice way to associate this with. So as I mentioned, and as Lynn mentioned as well, I am Megan Wallace. This is all my contact information. My office is actually in Bethesda, across from the Roundhouse Theater, if you're familiar with that, near the intersection of East-West Highway and Wisconsin. So more specifically, 4520 East-West Highway, but you can always contact me or reach out to my website if you are interested in more detail about the location. And I am licensed in DC, Maryland, and Virginia, and Georgia and Michigan, but those hardly ever come up in this area sometimes. So I'm happy to help you with any jurisdictional questions you may have, because there are differences, as you well know already in your daily life, there are big differences whether you live inside the district or outside the district. So all that is taken into account with a properly drafted estate plan. So what are the kinds of things that we'll be looking at? We'll be talking about a will. Sorry, I think this is the one you can see. We'll be talking about a will, of course. We'll also talk about revocable living trusts and how those may assist you or your family during your lifetime and also at death. We're going to talk about a very important topic of beneficiary designations. Much of people's wealth these days is wrapped up in the type of assets that pass by beneficiary designation, so that's very important. That leads us into a nice discussion about planned giving opportunities that you may have using beneficiary designations or in a will or a trust. Then we'll also touch on durable general financial power of attorney, a durable power of attorney for healthcare, as well as a MOST document. That's a medical order for scope of treatment that you may or may not be familiar with, as well as a Hipaa release and authorization. So a lot to get through. We may or may not get to every single thing today, but hopefully we'll get through, most of it. As I mentioned, if, looks like I already transferred the slide, that's okay. If you don't have an estate plan in place that you have done, then you certainly have one based on what the jurisdiction has put in place for you. In DC, if you don't have a will or a trust directing otherwise, then under the intestacy laws of DC, if you are married, your spouse would get 2/3 of the estate. And if you have children, whether they're minors or adults, it doesn't matter, they would get 1/3 of the estate. So if you're married with children with no will in place, spouse gets 2/3, children share 1/3 of your assets, okay? That may be fine for some of you, but maybe not for others. If you're in perhaps a second marriage and you pass away without a will, then your spouse will get half of the estate. And if your spouse has children from another relationship, not your children, then they'll only get half, and the remaining half will go to your children, okay? If you have parents and you have no children, then your spouse gets 3/4 and your parents get 1/4. And if you have no spouse, but you do have children, then 100% goes to your children. Now, we can keep going on down the road, because if you don't have children, you don't have a spouse, then we're going to go up to your parents, presuming they've predeceased you. We're going to then go to your brothers and sisters, and then we'll go on down the line to nieces and nephews, etc. Keep in mind that under intestacy rules, it doesn't matter if there's a child or a sibling that you don't get along with. The law is not going to take that into account. That's again why you might need a will to change that plan. So you may need a will in order to properly take care of your family and direct assets other than what the DC code allows. Many times, clients in this situation They don't anticipate having to share assets with their children so long as their spouse is alive. It kind of comes as quite a surprise because you or the two of you are looking to use all of the marital resources, to continue to take care of you and your surviving spouse, throughout your lifetime. So if you suddenly have to share that with your adult children who may be doing just fine, well, that depletes the resources available to you to take care of you for the remainder of your life. Oftentimes, that's not what's preferred. Just like you're accounting on all of the assets of the marriage, so is your spouse, or whatever assets there may be there. Keep in mind that in a will, you don't have to list every item. Some clients get quite overwhelmed thinking, oh, I can't even get started. It's just too hard. There's just too much to think about. What I really encourage you to do is to have that conversation with, an estate planning attorney. And like I said this morning to a client, I literally said, just tell me what you want and I know how to make it happen, right? You don't have to know all the mechanics walking into a meeting in order to come out of that meeting with a really good estate plan. I just need to know, or your attorney needs to know, what are your goals? What is it that you want to have happen? And I'll figure out and know how to make that happen for you. So this today will be a really good overview for you of the entire, process, but also understand there are other options out there with respect to ways to dispose of assets. And I'm really just scratching the surface. So we can get as interesting as you'd like with leaving assets to others upon your death. And again, it's really just about your goals. It may be really important for your one or all of your children to have their assets in trust. And we'll talk about what that looks like too. But in a will, you have the ability to name a personal representative. And again, the code will do this for you if you choose not to, but most of the time, people really want to choose their own personal representative. Maybe that's a close friend, maybe it's an attorney, maybe it's an adult child who's, perhaps very responsible and very fair with the other siblings, if there are any. And also, quite honestly, good with paperwork, because it is a real work of exercise to do all of this paperwork that is required throughout the probate process. Even if we avoid probate, there is still a significant amount of paperwork. So you want to choose somebody who is responsible, responsive, and also fair to those who they are there to serve, meaning the beneficiaries of the estate. So not someone who is kind of a lightning rod, perhaps, more of a peacekeeper. If that becomes an issue in your family, hopefully not. But again, you can choose anyone you'd like as a personal representative. And the job of that personal representative after you pass away is to basically collect. Was there a question?
I don't think I'm watching
okay.
anymore. Yeah, I'll be right.
To collect any assets due to you, okay, to pay any debts that you owe. And maybe, maybe you don't really have debt during your lifetime, and that's fine, but there may be debts of your last illness, perhaps, your last cell phone bill. I mean, things as simple as that, your last cable bill, all of those kinds of little things need to be addressed. And also then ultimately distributes the assets according to your wishes. They file your last tax return. This is someone we hope it will be kind of a short-term job. We try to wrap up most estates within a year or two. To be perfectly frank right now, in DC in particular, it is taking us months just to get the estate opened. That's primarily due to COVID. With the shutdown and very limited staff still at the courthouse, it's very challenging. There is a good question here in the chat, and it says, under intestacy, who gets asset if you have no spouse, no siblings, no children? But in this particular question, they mentioned there is a niece and there is a nephew. So what we look at, and I should have had I have these charts that are fascinating. They're charts of consanguinuity. So it shows us where do assets go. And, it starts with you as the decedent, And then, we look to your children, et cetera. But then if you have no children, no spouse, right, and no parents who are still living, and no siblings who are still living, well, then we keep going. And so we look at those siblings, children. So in this case, the question that was posed, the assets, unless otherwise stated, would be split equally between the one niece and the one nephew, without regard to whether or not they have children themselves. So we would get to that level where there was someone who would take, and it would then go to an equal shares, those individuals, okay? So that's a simple answer to that question, but that's where that would go. It would go to the niece and nephew in that case. So thinking again about the personal representative, you absolutely want to choose somebody who is trustworthy. Someone who has had the unfortunate experience of filing bankruptcy may not be a good option. Obviously, if they've been convicted of certain felonies regarding finances, they are not allowed to serve. So keep that in mind as you're choosing individuals. You need someone who is trustworthy. They don't have to be local. So if you've been here for decades and raised your children here, and now your children have moved away, well, that's fine. They can still serve as your personal representative. They absolutely do not have to be a resident of the District of Columbia. Now, it's easier, or it's at least easier if they're here in the DC metro area, but not required at all. I work with personal representatives who are, quite honestly, all over the country. And we can get it done pretty much just as well. The challenge is the physical work of like cleaning out, a house or cleaning out a condo, et cetera. So understand that you may choose anyone you would like. There's a good question now about how to minimize inheritance, estate tax, and minimize tax considerations. And I will be talking about that. And so I will get to that question.
Okay.
Another thing is that, again, we hope that personal representative job will be more short term. When we talk about trusts, and I'll talk about those in just a moment, those are certainly much longer term jobs. But the primary job of that personal representative or executor, in this area we tend to say personal representative, then they will be ultimately distributing the assets according to your wishes. It may be that the person that you would like to receive your assets, that those assets can simply go outright and free of trust. So here you go. I have 2 children and I just split everything between my 2 children outright and free of trust. It's their money. They can do what they want with it, et cetera. It's subject to their own creditors, relationships, et cetera. Alternatively, you can leave assets for them in a trust. We'll talk about trusts in more depth in just a moment. You should also, though, consider what is in this absolutely catastrophic situation. You are gone. Maybe you have a spouse or no spouse, but your spouse is gone. All your children are gone. Then what, right? So then what do you want to have happen? At that point, many people will say, okay, then I want to benefit, various charities. That's absolutely fine. Or they want to choose certain family members that they want to benefit, or certain friends or other entities that they may want to benefit. We can do all of that in a will or in a revocable trust. Now, with respect to the tax situation here in DC, DC fortunately does not have what's called an inheritance tax, which is very good. Maryland does have an inheritance tax. DC does have a separate estate tax. So if you live in DC, then you have an exemption of $4 million that you can transfer to anyone upon your death, any one or any number of people. But what we're going to look at is what is your gross estate worth on the day that you died. And keep in mind, that includes like everything you had control over. Okay, it includes any real estate you own. It includes your cash accounts. It includes your vehicle. Even if you have a really old car, it still counts. It includes the death benefit of any life insurance proceeds if you still own that life insurance policy in your own name and you are the insured. Maybe your children are the beneficiaries, but we're going to count the value of that entire life insurance policy. It also includes any retirement account that you may have, be that TSP, 401k, SEP, IRA, whether it's traditional or Roth, brokerage accounts, savings bonds. I'm seeing lots of paper savings bonds in my office these days. Those of you who have not converted those to electronic, you may want to consider that. Also, word to the wise, please look at your savings bonds and make sure if they have a beneficiary named on them, that that's still the person that you want to receive them. Unfortunately, I'm finding that some of those are going to people who are no longer in someone's life for one reason or another. So if you have savings bonds, please take a look at those. The federal estate tax exemption this year is $11.7 million per person. If you are married, then you and your spouse can share that so that you're actually doubling the exemption amount for the married couple. So you have just over $23 million that you can transfer without incurring any federal estate tax. Keep in mind, the DC estate tax at $4 million is going to come in first. So any tax planning we may want to do is more likely to be looking at that $4 million. So one of the questions was, someone is looking at leaving an inheritance to their two children, and they want to minimize that tax impact. Well, there's a couple of different kinds of tax that we have to think about when somebody passes away. One is the estate tax, which is what I have been just describing. We're going to be looking at your gross estate for estate tax purposes. So if you tip the scales at $4.5 million, then we have an estate tax filing requirement. You're only going to have to pay the tax on the differential of anything over $4 million. And there are lots of deductions that come into play, debts, administration expenses, funeral expenses, et cetera, charitable bequests, all of that. So it may end up being that you actually owe no tax, but that's the estate tax piece of things. There is no inheritance tax, so that's really good. So leaving assets to your children, or anyone in DC, no inheritance tax. But what you may want to do with thinking about leaving assets to children or others is making sure you're taking advantage of that $4 million exemption. That's really only relevant if your estate is over $4 million. So if you think about all the things I listed, fair market value of your house, okay, not what you might have paid for it decades ago, but we're looking at what's the fair market value on the day that you died. Also life insurance proceeds, retirement accounts, brokerage accounts, et cetera. If that whole big bucket is less than $4 million, no real tax planning necessarily needs to occur. There are other reasons why you want to leave assets in trust potentially for children or others. Now, the income tax piece of things is a little bit different. The income tax piece of things really is what might affect children or whomever you may leave assets to, because if a significant portion of your assets are held in an IRA, a traditional IRA, a 401k, a SEP, TSP, or something of that nature, well, just like now, when you take required minimum distributions, you have to pay income tax on those distributions. That does not magically go away when you die. Whoever it is that inherits that IRA or retirement account, right? So there's a big umbrella of what could be a retirement account. Those individuals, as they take distributions, also have to pay the income tax. There's not anything to be done about that, about the income tax piece of things. I mean, unless during your lifetime you converted everything to a Roth IRA and you paid the income tax during your life, which would be a lovely gift. But that can be a significant tax bill. But basically, no one's going to get out of paying the tax on a taxable IRA. Also now, and I'm just, this is a little bit later in my presentation, but I think it fits well right now, is you may have heard about the Secure Act that was passed in 2019. Now, we can no longer stretch out the distributions of those IRAs over someone's lifetime. They have to be paid out within 10 years of the participant's death. unless you're a spouse. Okay, so the number one standard would be leave any retirement assets to your spouse if it makes sense for your situation. Otherwise, if your retirement assets go to, your adult children or whomever, they have until the 10th year after your death in most circumstances to take out all of those assets and recognize all of that income. That's only if there's a properly completed beneficiary designation. And I cannot stress that enough with retirement accounts, okay? So we'll talk about beneficiary designations more, but so critical when we think about retirement assets.
And Megan, interrupt you just 1 minute. We have a couple of good questions.
I see those.
Okay.
I'll answer those.
Okay, so you want to just handle them, or shall I read them?
Yes.
Okay.
I've got them right here. I'll take a look. So the one question is it advisable to have an attorney to be the person named to help the personal representative? Okay, so not naming the attorney as the personal representative. I am not a big fan of that. I'll be honest with you, because what if your longtime attorney retires themselves? Then who does your person work with? And maybe your personal representative should kind of have that freedom of choice as to who they would like to work with. Now, you can always leave a suggestion and you can say, I had a wonderful experience with so-and-so, and they're ready to help you, when I pass away. I certainly have a lot of clients for whom I've drafted an estate plan that when they do pass away, then the personal representative hires me to help them facilitate handling the administration of the estate. I have seen, this is usually in older documents, where they've kind of said, you must work, with such and such attorney. Again, what if they've fallen ill? What if they are no longer practicing, etc.? So I like a little freedom of choice, but that is also, it's worth a conversation with your personal representative to say, I liked this person, we had a good experience, I think you should probably use him or her, when the time comes. I also meet with families sometimes because they're like, hey, Megan, you're the one who's going to be helping, when this happens. So sometimes we'll just have a family meeting before someone dies so that a potential personal representative can answer, ask me questions. I had that this morning. They were asking me, well, what happens when mom dies? What do I do? All of that good thing. So another question was, are assets in the gross estate only in the US or global? We're going to be bringing everything in just like they do for US income tax purposes, but there would be deductions and changes for assets that are not located in DC. So if we have to file in multiple jurisdictions, which is not uncommon in this area, we have people, of course, who live in DC and have a beach house in Maryland or a beach house in Delaware, or own part of the family farm in Wisconsin or whatever it is. We may have to file in multiple jurisdictions. So there are some carve outs for those when tax is due in other jurisdictions with respect to tax. If you give your IRA to charity, no tax, does this lower the estate value? I love it if you are charitably inclined and you have taxable retirement assets, that is your very best bucket to use to give money to charity. Okay. And when I say charity, I mean a qualified educational institution, a religious organization, any type of entity that's recognized, as tax exempt, because that's not income to them. And yes, it is a deduction for your estate. Now, if you pass away and you have $6 million in that estate tax bucket that we discussed, and 3 million of that is in an IRA that you're giving to charity, well, we still have a filing requirement because you tip the scales at just over 4 million, but we wouldn't end up writing a check, because from that 6 million, we're going to then on the tax return, just like you do on your own 1040, back out any charitable deductions. And that'll get us down then under the cap, under that $4 million. Therefore, we don't actually have to pay any estate tax. Also keep in mind And this is all, all this is wrapped up in planned giving, where an IRA is a great asset to look at for planned giving purposes. If you have $100,000 in an IRA and you have $100,000 in cash or a life insurance policy, well, that cash or life insurance policy is far more valuable to your children, because if you gave them the IRA with $100,000, they have to pay their income tax at whatever their rates are, maybe 35%, when they start taking those distributions. So it's far less valuable. Not the same with cash. So if you're looking at what bucket to use for charitable contributions, those taxable IRAs, not a Roth. I want it to be very clear, not a Roth. Traditional SEP, simple, TSP, 401k, et cetera, perfect place to find money for charitable causes. And you would do that by naming the charity, the entity, or the entities on a beneficiary designation. That's the way that actually would happen. So yes, it does lower the estate value. Another question here is, are there limits on what the personal representative can charge to the estate as part of handling the estate? And do those costs lower the estate value for tax purposes? Yes, they do lower the the value. Again, it's a deduction. So it's not going to change whether or not we have to file a return if you're over the $4 million mark. But yes, it is a deduction against the assets. And so ultimately, just like a deduction on your own 1040, yes, it will reduce that. Would it be enough? It's hard to say. That's also income to your personal representative. So if your personal representative takes payment for their services, that is reportable income to them on their own tax return. So a lot of times family members or those who are already going to inherit don't tend to take commissions, but they certainly can. In DC, they're called reasonable. Maryland has a statute that has very detailed amounts as to what people can get, but DC doesn't have that. In DC, it's simply reasonable. So what is reasonable? It's really hard to know what that is. It kind of makes a difference as to what makes up the estate, how much work did that person have to do, et cetera. So there's a lot that goes into that, but the limit would be reasonableness. And those who would be looking at that would be the other beneficiaries under your estate plan, because they can challenge that if they feel like it's not reasonable. So just continuing our discussion about how transfers occur, what can be disposed of, in a will? Well, those are only assets that you own in your own name or as tenants in common. Okay, so in your own name is considered like fee simple, like you own your own checking account, for example. Maybe you own your own real estate, alone by yourself. Or maybe you own assets as tenants in common, like a beach house with a sibling. Maybe you own that as tenants in common. So your 50% will transfer under your will if it's in the will and not in a trust. Whoops. Also, if the estate is named as a beneficiary on a non-probate instrument, then also that asset would pass under the terms of your will. I can't emphasize enough that I hope to heavens you don't do that with any retirement accounts. If that's the case, where you have failed to name someone on a retirement account as a beneficiary, the assets have to be paid out within 5 years, much faster income tax recognition there. So what cannot be disposed of using a will? Well, non-probate property, because the will only controls assets that go through probate. So if you have a properly completed beneficiary designation on an asset, well, that's a contract between you and that institution. So that will control that asset completely, regardless of what you wrote in your will. If you own assets as joint tenants with rights of survivorship, or as tenants by the entireties, which is only available between a married couple, but joint tenants with rights of survivorship, that could be with a sibling or a friend or anything else. Those assets do not get disposed of through a will, because by operation of law, they immediately belong to the other person the moment that you pass away. Trust property does not get disposed of under a will, because any assets held inside a trust avoid probate and are distributed according to the terms of that trust document. We've talked about the beneficiary designation form. Similarly, if you have a bank account or a stock account, then maybe you have done a POD, payable on death, or a TOD, transfer on death. Okay, those are like beneficiary designation forms for those types of accounts. There's just a question here, and I'll talk about this a little bit more when we get to planned giving. So I do see that question, and I will certainly talk about that when we get to the planned giving piece of things. Let me just touch on as well, trusts. Trusts are a wonderful way to do lots of good planning. I can do the same planning inside a will that I can do inside a trust. So I want to be very clear that there is no tax magic that I can perform inside a will that I cannot also perform inside a trust. Also, a trust is not a revocable trust. Okay, so revocable meaning that you can change it anytime you'd like. It's fully revocable. You can amend it anytime you'd like. You can put assets into it. You can take assets out of it. Those types of trusts, which are very common, do not have any tax savings benefits to them whatsoever. Anything different than what you can do in a will. So we can still save taxes by putting assets in a trust for a beneficiary up to that $4 million level. But the revocable trust itself has no tax magic around it. So during your lifetime, any tax effects that occur inside that revocable trust are simply reported on your own 1040, just like as if you owned them. That's completely different if you set up an irrevocable trust, which I think is beyond the scope of our discussion today, but I want to be very clear about that. But a trust, a revocable trust that you work with during your lifetime, has lots of advantages. Some of the key advantages are when you pass away, any assets inside your revocable trust avoid probate completely. Now that means they have to be titled in the name of the trust. So for example, we can put your house in a trust. We can put a brokerage account in a trust. We can put a cash account in a trust. We can put the entire contents of your home, all of that tangible property, inside a trust. Many things. What we cannot put inside a trust are your retirement accounts, 401ks, IRAs, etc. Those must stay in your individual name. Now, when you pass away, you can still name the trust as a beneficiary, but I would only do that with the advice of counsel, because that would only be if you want those assets to be managed for a particular reason. So I would not encourage you to do that on your own without talking to someone about that. Other good reasons for using a trust is when you pass away, those are private documents. They are not part of the probate file. Whereas when someone dies with just a will, then that will is part of the probate record and anybody can go read that will if they would like. Very interesting reading, I'm sure. But a trust, however, is private and does not become part of the probate folder that someone can actually go and see. Now, if you have a trust-based plan, we still need a simple will. And that simple will says, okay, anything I didn't put into my trust during my lifetime, I'm going to put into my trust at death. And, you know, my daughter will be the personal representative. And if my daughter can't do it, it'll be my best friend. Well, that's not very interesting because it doesn't tell us who gets what. It just says everything goes into the trust. So now what does the trust say? Well, that's a private document. And so the public cannot see that. They cannot see that trust document. So that's very, very helpful. Many people like that. Other key reasons and advantages to a revocable trust is, and this is one I think is very important, asset management during your lifetime. So as you age, and you know, honestly, particularly for single individuals, but also those who are married, they're wonderful to help with asset management during your lifetime. As you age, should you get some type of diagnosis of cognitive impairment, dementia, etc., or other, you know, physical maladies, well, if you're not up to the task of managing your assets, a successor trustee, who's someone that you've chosen, someone that you trust, can so easily just step right in and start to manage those assets on your behalf. It is a beautiful thing when that occurs because that person is properly planned. It makes it very easy for be it your spouse to step in or your children to step in or your best friend to step in or your attorney to step in or whatever, to then manage those assets for you in the time frame when you're not able to do that for yourself. So really, really helpful. And also at the time of your death, it does allow for a faster distribution. We don't have to have a probate estate opened for assets that are held in a trust. So much faster distribution. Just going to take a look at some of these questions.
Megan,
I do see the one.
So you have a couple of questions here.
Yes, thank you. I will get to the planned giving one in just a moment.
Right. We also have one about a bank. Is a bank account with a POD, a payable on death, excluded from your gross estate?
Yes, I see that. And the answer is no, because again, it's something that you've controlled and that it passes because you passed away. So any assets, whether they're probate, like going through your will, or non-probate, passing through a trust or a beneficiary designation or something like that, those are all part of your gross estate. Okay, so whether or not it goes through probate is not relevant to whether or not it's part of your gross estate. It's everything that you own and control at the time of your death, plus like 10 other code sections in the Internal Revenue Code that I won't bore you with, but anything basically that you own and control, including, for example, let's say you are, a married couple, you own your home together and you've owned it, forever, or maybe you've only owned it for a month. Well, your 50%, while it does, yes, go automatically to your surviving spouse. So there's nothing that we have to do, in the court about that. But for tax purposes, we're going to use half the value of that house. So keep that in mind. So not excluded from your gross estate. Another question with respect to expenses, if the personal representative hires an attorney to help or has other expenses, I'm assuming those expenses do not count as income from the PR. That's correct, because they're being paid out, right? So maybe they're being paid to a law firm, maybe they're being paid to an accounting firm. So they are not being paid to the personal representative. Those are called costs of administration. And so court costs, filing fees, all of that good stuff. And even any expenses the PR themselves incur, postage, FedEx, hiring somebody to clean out your house, none of that is income to your personal representative. Those are all expenses of the administration of the estate. So I just wanted to make sure that I covered everything that I wanted to cover, just simply with respect to a trust. Also, and I certainly hope this doesn't apply to your situation, but if you have family members who may be unhappy with your distribution plan, then it is much harder to contest a trust than it is to contest a will. So it's pretty easy to contest a will. Now, it's not easy to win that contest, but it's easy to launch a contest. Much more difficult to contest a trust. As I mentioned, there's no income or estate tax savings as you continue to own all of the property. You, the grantor, own all of the property in the trust. So also, there are other types of trusts. Now, I'm not going to discuss irrevocable trusts today, and I'm bumping up here on running out of time, and I've not hardly gotten to what I wanted to get to, but there's also testamentary trusts. Those are trusts that live inside the will. Those are trusts you may want to consider if you need your assets to be managed after your death for the benefit of another person. Maybe that other person is your spouse, because maybe your spouse is no longer well enough to manage their own assets. Maybe they spend too much money during their lifetime and you're worried that they might blow through all the money, so you want to put somebody else in charge of it. Maybe you're concerned about a future relationship, so another reason to use a trust. There's lots of good reasons to use trusts. Another good reason to use a trust, a testamentary trust, that's a trust that lives inside your will, or even one that lives inside your own revocable trust, is because we can then capture that $4 million of tax exempt funds so that when your spouse dies, they have their own $4 million to use. So I'm going to leave that discussion at that, because that gets a little complicated and we do still have other things to talk about here. So just to kind of recap, about transfers outside of probate, because I know it's really important to many people to avoid probate. Your beneficiary designations avoid probate. You can use those on so many things, life insurance, retirement plans, et cetera. Assets held by as joint tenants or tenants by the entirety also avoid probate. And then those assets held in a trust. And then also perhaps there are assets that are going to be subject to a premarital agreement. I think we've talked about this quite a bit with respect to probate and non-probate. Just so I can get to a few other things, I'm just going to go through that. What to consider as part of developing a proper plan is, who really is the best person to receive your asset, or persons or entities. So a charitable entity might be a very good entity to receive the assets. And again, just to clarify, any assets that pass by beneficiary designations go to that individual or that entity. I absolutely see things where people have unfortunately continued to leave on a former spouse. That spouse gets those assets in most cases. Maybe they have named one of their children saying, I know they'll take care of their siblings. There's a lot of gift tax reasons why you should not do that. But there's a lot of wealth that can be managed and transferred outside of probate, but you just have to make sure that you've done the documents correctly. And also, just with respect to plan giving is all about legacy gifts, right? So maybe your college has contacted you, your educational institution, about providing some type of legacy gift. Georgetown Villages, for example, would gladly accept any type of legacy gift that you might provide, to them. And as we touched on, some of the good things, good assets to use for that would be those IRAs, for example, appreciated stock, right? So when someone dies currently under the current plan, you get a step up in basis. So if you bought a share of Apple stock for $100 and now it's worth, I actually don't know how much it's worth, but let's say it's $1,000, or Berkshire Hathaway or whatever it is. Well, at your death, that stock gets a step up in basis. And so someone's going to recognize the step up in basis would be very helpful. You, though, could, during your lifetime, donate those appreciated securities so that you can avoid recognizing that income tax. Cash obviously is great for plan giving, but the retirement accounts are where I'm really seeing it these days. There was a question.
Megan,
go ahead.
I think that's a great time for me to introduce Barbara before you finish up your program. And
sure.
We will go back to you. And by the way, as I reminded you, no pressure. We are happy to have you back for part 2.
And I'd be happy to do it.
Okay, so I would like to, it is my honor to introduce our development co-chair, Barbara Hall, who will just be speaking for a few minutes about Georgetown Village and some of our plans. And then we're going to go back to Megan to finish up the session. So, Barbara?
Thanks, Lynn. First, Megan, thank you. This has been terrific, very, very informative. And I want to promise all of you, we're going to get back to Megan very quickly. But as co-chair of the development committee of Georgetown Village, I would be remiss if I didn't let all of you know that Georgetown Village welcomes legacy gifts as well as lifetime gifts. And we'll hear more from Megan about this. But I think all of us want to ensure that Georgetown Village is here for years to come. And the 2 easy ways that I would recommend, and this is for myself as well for others and my experience as well, the 2 relatively easy ways to do this. And it's not just for Georgetown Village, but any not-for-profit that we want to benefit. One is making Georgetown Village or your favorite organization a beneficiary of your IRA. And Megan's already mentioned that. And I too am finding that many not-for-profits are marketing that to their stakeholders, because it is easy, relatively easy to do. It is revocable. You can certainly make a change, and you'll avoid estate and income taxes doing that. And the second thing is pretty obvious, and that's doing a bequest. And those are the things that I'm going to stop there. I just again, Lynn would run me out of town if I didn't make a plug for Georgetown Village. So back to you, Megan. And I may have, I worked in plan giving for many decades. I may have questions later, but I want to get back to you right away. Thank you all.
Thank you, Barbara, very much. And Megan, back to you. I just felt it was a good time. Thank you.
I think that was the perfect time, for that. I think plan giving is very important. I think, Barbara and others, one of the very best things that you can do, let me just make sure you're seeing my proper screen here. Okay, you're seeing it. I think we're good. Okay.
Yes, we've got the plan giving slide. You're good.
Okay, thank you so much. One of the best things I think Georgetown Villages and any other institution can do is have that bequest language, the preferred bequest language, readily available on the website. As an attorney, I go to websites all the time hoping to find the bequest language, and it's so helpful to me if it's just easily and readily available, which would include, the address, the EIN, all of that good stuff. And, so I would encourage you guys, as you're developing this, to consider making sure that you have that. So as I turn now to just briefly, because I really do want to have questions, I know we're supposed to wrap up at 6:30, but the other documents I'm going to talk about now have nothing to do with your death and everything to do with your life. So they really are about planning for perhaps disability during your lifetime. It's extremely important to have these. While there is a plan in place under the code, if you pass away, there's often not a plan under the code if you don't have these types of documents in place. So first, I want to talk about the financial power of attorney. This to me is one of the most important things that you can have in place. What the financial power of attorney does, it allows you to name someone to step into your shoes if you become unable to manage your own affairs. Now, you might think, oh, well, my spouse can do it. Well, if your spouse is not on your account, on each and every single account, then they don't have access to that account. It doesn't matter how long and happily you've been married. If only one of you is on the account, then only one of you can control that account. So a financial power of attorney, extremely helpful to have that in place before you become unable to sign that document. I had a really challenging meeting with a family the other day because they had waited too long, and now dad wasn't able to sign any documents because he no longer had capacity. So something that's really important to have in place before that time comes. It would allow someone to step into your financial shoes and manage your assets. Now, that's a very powerful document. So obviously you need to choose someone that you really, really trust. You probably have heard horror stories where people abuse these, and like one child redirects all of the assets, so only that child gets them. Well, hopefully that would not be the case in your family. That said, very important to have them. If you don't have a financial power of attorney in place, and you also don't have a revocable trust in place, and you lose capacity, we will have to go to DC Superior Court and get someone named as your guardian or your conservator. That, even if it's your spouse, people are like, why would I have to do this? This person is my spouse and has been forever. They don't have any greater right to your finances, unfortunately. So going to court and getting that is sadly an expensive and arduous process. Not something I want people to have to do. Honestly, a power of attorney like this, I'm just going to tell you my rate for doing those. Well, I'm going to say it's low because just for doing the power of attorney, because it's so important. So you don't have to do that with me. Just do it with someone. If you think that that's important for you. The other type of document that I think is really important is some type of healthcare power of attorney. In DC, we call them durable power of attorney for healthcare. You may have heard of them as advanced medical directives, a living will, something like that. This also allows someone else to step in and make healthcare decisions for you if you cannot do so. So keep that in mind. Very helpful because you get to express your wishes during your lifetime. We also have things now like a dementia directive, like what if you have dementia? We can also address organ donation, burial plans, etc. So you want to choose someone who will honor your wishes. If pulling the plug is something that's important to you, then you want to make sure that you line up with someone who will do that. The most important thing, though, is that you talk with your family or whoever your agent is about your wishes. I would imagine that many of you might recall that unfortunate Terry Schiavo case many, many years ago in Florida. What you might not realize is that young lady was, I think, 27 years old when that occurred, when her unfortunate medical situation occurred. She was only 27. So all people need medical directives.
And I just,
Hipaa
I'm sorry, I just want to add that Georgetown Village has copies of the 5 Easy Wishes if people.
Oh, I like that.
Yes. So that if you need a copy, please contact us. If you are a community member, we'll be happy to share it for a donation.
I love the five wishes document. If you're not familiar with it, it's just a really nice way to walk through your decision-making process, both for your medical care as well as what you would like to have happen after you pass. So it's a lovely, lovely document. I highly recommend taking a look at that document. The Hipaa release and authorization, this is simply access to medical records. So for example, I have one for my mother who is 89, so that I can call and talk with her doctors and understand when she's not able to really explain to me what's happening. I can talk with them directly and understand what's going on. It doesn't give me any power, but it just simply allows me to have access. So I know that a do not resuscitate can become important as you age. Honestly, one of the best things you can do to effectuate that is to get a bracelet or something of that nature, because those are really, really hard for people to get access to immediately. I think you've probably heard, put it on your refrigerator, etc. Well, that's great if you fall ill in your kitchen. But if that's not where you decide to fall ill, you need to have something else. So perhaps a bracelet. I don't know if you want to go the route of a tattoo. That seems like a lot. But I guess it's an option. So
okay,
we talked.
Can I just, Megan, if I could just add to that from the social work perspective, and what we've learned is if you have a do not resuscitate, one of the best things you can do is ask somebody not to dial 911. Because the issue is whether you have a tattoo or not, if you call 911, their mandate is to do everything to help you. So it's important to remember that, anybody who's going to be with you or who you feel like might walk in and find you, to tell them not to call 911. Sorry, but that's the reality.
Okay. So that's really my presentation. There is a couple questions maybe, and I'm very happy to have more questions just as a dialogue, but someone asked, what's the difference between a legacy gift and a bequest? It's just kind of language. A bequest is something that we put in a will or a trust. So when I die, I give $5,000 to Georgetown Village, that type of thing. That's a bequest. Legacy giving may also include things like gift agreements with large institutions, like to endow a chair for a professorship or something like that. All of those types of things come under that umbrella of planned giving or legacy gifts type thing, whether you have naming a bequest in your will or your trust, or perhaps you're just simply naming them as a beneficiary of another asset. Another question is, how does one make changes to these documents once they are in place? Is it as easy as making the change on the document with initials, or must an attorney write it? Please, please, please don't ever write on your original will, please. That is the fastest way to cause so many problems down the line. Honestly, we've had wills hung up for just a stray pencil mark. It's really frustrating and sad and is not at all what you intended because you spent the money to get a plan in place. Please, please don't write on an original will. Are there ways to do it? Absolutely. Do those kinds of questions end up on my law school exam? You bet, because that's the fastest way to, one, for an attorney to earn more fees, because that is going to be a source of consternation for the probate office, for the judge, and everybody else. And please don't do that. If it's on like a medical directive and you're talking about somebody's address changed. So on my medical directives, I put your agent's name and address and phone number. And if all you're doing is changing somebody's address, okay. If you're changing out that agent completely, please come back to me, or just do a new one, right? Get another 5 wishes document from Lynn, and just do a new one, because what happens later when you're not able to communicate with us because of disability or death, that those types of things can really cause challenges in the future. Does it make sense to leave assets into your estate instead of named beneficiaries? It completely depends on the kind of asset. So that's not an answer I can just say yes or no, because if you did that with a retirement account, it would break my heart, because the income tax effects are much different than if you name an individual or an entity like Georgetown Village. So there it would be terrible. If, however, it was life insurance and you knew that you needed to spread that money out among a lot of people and some needed to be in trust and some didn't, well, then maybe that is a fine thing to leave, directly to your estate. But also then that money becomes subject to your debts. Whereas if you name a beneficiary or several, then that's out of your estate and not subject to your debts, except in certain circumstances. Do I have a checklist of records we should have for when a husband passes to be prepared for taxes and forms that the government needs? I do not have such a checklist. Everybody's really most people are different, because if we have to open a probate estate in DC, well, there's a couple different types of probate estates that we may have to open, or not all at once, right? We have a choice, right, between a couple different types of probate matters in DC. So we'd have to get the right one, and that would be hard to know in advance what that would be. Also, the tax returns, well, those change. So that really isn't something that you could do. But what I will say, one of the best things you can do, and one of the things I'm finding people are not doing as they should when they age, because they get worried about privacy and they get nervous about sharing information, particularly perhaps with their adult children who they still see as, that crazy 15-year-old. Please talk to people about your assets. As you're aging, it's really your kids. Well, I guess I can't say that for sure, but hopefully your children aren't trying to take your assets. They just need to know where to look when you pass. A lot of times we have to do some sleuthing when someone dies, because they're like, Dad would never tell us anything. We have no idea. I literally have an estate going on where the family really had no idea. Dad had handled everything. And, they lived in the same house they'd lived in since the late 60s. Well, it's a multi-million-dollar estate. I mean, and no one had any idea that they had this kind of money. Is that good? Is that bad? There's a lot more I could have done during his life if I had known, if I had been able to get involved earlier. So, and now I'm spending a lot of time trying to find a lot of those assets. So please talk to your family about your assets. If you trust them, and if you feel like that, it's just so hard when somebody dies and nobody has any idea where to turn. Let's see. Oh my goodness. Somebody said the attorney who drafted my power of attorney and healthcare proxy won't give me the originals. She keeps them in a safe. Is this usual? No. No. I don't understand that. So I don't understand that, because if you hired this person and you paid that person, those are your documents. So I don't really understand that. Now, what I do, though, I will tell you is, for example, with a healthcare power of attorney or financial power of attorney, my clients, if they're able, sign 3 originals, and I keep 1 original, but I send them home with 2. And I always say to them, I have them right here in my file, and anytime you need them, I have them right here. And I get calls from an emergency room. I get calls from a funeral home. I get calls from wherever, and they need those documents. And because I do have a set of originals, I can help facilitate that. That's why I keep a full set, because what if a fire, who knows? Now, the original will is a completely different story. There can only be one original will, so we don't do multiple original wills. And I always offer to my clients, you can take it with you, keep it a fireproof, waterproof, but findable location, or I'll keep that document for you. And I truly say to them in my meeting and in my letter I follow up with, this is your document. Anytime you want it, I will return it to you. Whether you're just going to go to another lawyer because you don't care for me anymore, or you just feel better having it at home, it's yours. So I do not understand why. And I do keep them in a safe. I keep them in a fireproof vault that I have here. But again, I give them a copy and I tell them very clearly it's theirs. So I don't have an answer to that as to why that happens. Somebody says we have a will. I'm very glad for that. That's really important. Maybe they intended to say something more after that. I'm not 100% sure. I think you said there's no inheritance tax if you live in DC. What if you don't live in DC? Well, Virginia is in our DC metro area. Virginia is our little estate tax haven. There is no state level estate tax. So I actually have some of my wealthier clients from DC or Maryland who ultimately get up the courage and cross the river, and start to live in Virginia towards the end of their life solely for tax purposes, because they then are only subject to the federal limit. Again, this year, $11.7 million. Maryland, however, does have an inheritance tax. I don't want you to confuse inheritance tax with estate tax. Maryland has a state level estate tax. The exemption is $5 million. And Maryland has an inheritance tax that applies to those who are not considered close relatives. So those who are exempt from inheritance tax in Maryland are your parents, grandparents, children, grandchildren, and your siblings. Nieces and nephews are subject to inheritance tax, and it's approximately 10% in Maryland. Those are all the questions I see, but I'm happy to take more.
You've covered it all. You've done a fabulous job. Thank you so very much. It looks like we have a couple of more questions that are not in the chat. Barbara, I saw your hand.
Yeah, this is not a question, but just a comment. I just want to emphasize how important it is that your IRA custodian have the paperwork, the beneficiary paperwork. And it's not good enough just to keep it in your own files at home. They need
Correct.
to have the original. Am I
Absolutely.
right, yeah.
Oh, 100%.
And that it
absolutely.
doesn't matter whether your beneficiaries or charities or your children and others, they must have the original of your IRA beneficiary form. So
Absolutely agree 1,000%. What the document that controls is that one that is properly filed with the institution.
right.
So this is a really good time to write a note and spend the rest of your week calling your financial institutions to make sure about who your beneficiaries are, because
right.
people forget, people think, of course it's my spouse, of course it's my kids. And then they look back and it's like, I don't even know who that person is anymore. So
right.
please
right.
check them. Absolutely. Let's see, what is the estate tax percent over the exemption? It's a like income tax. It's this weird, funny scale, right? So, but it is approximately 16%. It can get to a top of 16% in DC. How do you plan when your estate is close to the limit? It may vary up and down given the market. Absolutely. There's only so much we can do, with respect to that. We can also write clauses that say, I give a charitable amount away so much as to, be required to get me under the limit. We can do that. That may work well for you and it may not. So it's hard to kind of tell you exactly what to do in that situation, because we don't always know what the market's going to do or what your assets are going to do, how much you're going to spend, or how much, are you playing the lottery and good things like that. So When your estate is close, maybe when you start to make gifts, maybe you start to make lifetime gifts. Maybe that might be a good plan for you if you feel like you have enough assets. Some people don't want to make, any gifts at all. But you can, gifting is a really good way to start to get that estate down. There's a lot of ways, a lot of really creative ways to make gifts. Gifts to Georgetown Village, that helps, gets it under, and you get a charitable deduction during your lifetime.
Absolutely.
Megan, one other question. What are you hearing about changes in the federal legislation with respect to estates and also DC? I've heard the reducing from for individuals from 11 back to 5 million or 3 million, and DC also getting the exemption being reduced.
Well, DC just went through a huge reduction. DC in 2020, the exemption was like $5.7 million in DC, and it came crashing down to 4 million now in 2021. It had been sitting at $1 million forever,
Right.
And then it started to go up. And right now it's at 4 million. I'm not hearing too much myself about DC, but at the federal level, there have absolutely been proposals about bringing the estate tax down, the exemption amount down. We were not expecting in 2017 for us to suddenly in December, the end of December, to get this huge change in the estate tax regime. So there has absolutely been some proposals and discussions about bringing that back down to what it would have been if it had stayed at its normal course back then. And I've heard things as $3.5 million. I've heard it, between $5 and $6 million. So, this is a great year to make some significant gifts if that's something that you're in a position to do and that you may have an estate tax issue to be concerned about. This is a great year to start making some big gifts if that's important to you. So it's really hard to know until those things are final as to what really might occur.
Okay, I think Emily, since you scheduled this, I'm going to give you the last question, and I'd like to thank Megan and wrap up. Emily.
Okay, thank you. And Megan, I want to thank you for really an outstanding job. I think you can see from the time we took, which is certainly beyond what we had scheduled, how interested everyone is in this. So I hope you'll keep us in mind. We'd like to have you back again another time.
I'd love to. Thank you.
Thank you.
And I want to add my thanks both to Emily and Carol, our programming chairs, as well as to you, Megan. This was really a fabulous presentation, and we will be contacting you for part 2, perhaps in the fall. I know a lot of people travel during the summer, but we thank you for joining us. I want to thank Hillendale. I know we have a lot of Hillendale residents here with us tonight, as well as members of other villages, and we appreciate your being here. This is being recorded. It will be available on the Georgetown Village YouTube channel. And if you need the link, that will be put on our homepage of our website within the next, by Sunday at the latest. So thank you for coming. Thank you, Megan. This was really so wonderful and a great presentation.
Thank you.
Thank you so much.
Thank you. Thank you. I appreciate it very much.
Thanks.
Thank you.
Bye now.
Okay,
Bye-bye.
take care. Bye-bye.
Great job, Megan. Thanks.
Thank you. I appreciate that very much. Thank you. Take care.
Bye-bye.
Bye
Bye.
all.